Good morning. Please be seated. This is the time set for argument in the case of Mesa Airlines, Inc. versus Paul Condron. Our civil number 16-0326. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We're at the briefs. We've been through the record. We've conferenced the case this morning. So I think we understand the underlying facts and the issues that are being raised. So please keep that in mind as you make your arguments here this morning. We're recording these proceedings, both by audio and video. The video eventually will be available on YouTube. As you approach the podium, though, I'd appreciate it if you would identify yourself and your client for us, in that way we can keep track of things. With that, Mr. Williams.
Thank you. My name is Darrell Williams, and I represent Paul Condron, not Condron. He's from Arkansas, so they say it the way they do in Arkansas. This is an interesting case because the issue is whether this oral employment agreement includes a promissory note for approximately $12,000 when that my client signed the day before he started his employment. He shows up at the training facility for Mesa Airlines, and they say, well, okay, here, sign this note. You can't work here unless you sign the note. He signs the note, having left his other job and with pregnant wife at home, needs this job, signs it. We have no issues of duress or coercion or anything like that. It's just clear that this is a part of his employment agreement, which was otherwise oral. The note is unusual because it was never expected to be repaid so long as Mr. Condron remained a pilot at Mesa Airlines for a year.
But if you look at the terms of the note and the collective bargaining agreement as well, somebody clearly anticipates not only that these agreements exist, but there are circumstances where they will have to be repaid because there's a procedure set forth to do that. Well,
the collective bargaining agreement also says, Your Honor, that Mesa Airlines will be responsible for the training of the pilot. So under the collective bargaining agreement, Mesa Airlines pays for the training. The collective bargaining agreement is permissive in that it allows a training agreement. And I think under that collective bargaining agreement, the word training agreement is used repeatedly in the section that deals, Section 8. This is page 35 of the collective bargaining agreement, appendix number 31 to the responsive brief. It says, may be required to execute a training agreement. There may be a training agreement. There may be a training agreement. If you upgrade, then there's an existing training agreement. Well, there's no training agreement. One was not signed. There's one in the record that was unsigned, and perhaps that was an omission on Mesa Airlines' part.
So is the argument that I'm having a hard time understanding the argument. Is your argument that it is not it illegally, impermissibly amended the at-will agreement, employment agreement?
Yes, I think that's exactly and precisely my argument.
And why is that impermissible?
Well, because employment in Arizona, by the statute, is at the pleasure of both parties. That's the express policy of this state. And so you cannot say, well, yeah, you can quit at any time. It's not a breach of your agreement. But if you do, you got to pay me $12,000.
But the CBA contemplated airline pilots who needed training that would be paid for by Mesa to execute a note, and even talked about how the face value of the note would increase over time with inflation.
Well, parties can agree to do something that is verboten under the policy of the state, doesn't make it any more effective.
Okay.
My position is that when you tell someone, you can quit at any time, but you got to pay me money to quit, that burdens the express policy of this state that says you can quit at your pleasure, because that's not pleasurable.
What would be different in what happened here than in terms of an overall consequence if Mesa Airline put the requirement at the beginning? You may come to work here, but you need to pay us up front the value of the training we're going to give you.
Okay, if they have an agreement that says that, and we sign that agreement, then we have to pay, we being the pilot. There's no such agreement here. And the statute at issue has got a couple of provisions in it that even allow you to, if you're the employer, to go on with this. And this is my last antecedent argument that I raise in my reply brief. Because it says, we can quit at my pleasure unless there's an agreement signed by both parties saying otherwise. But it also says, if you've got something in the nature of an employment handbook that itself says it is an employment agreement, this is your employment agreement, the employment handbook, then that'll work too. But if you have, like we have in this case, a collective bargaining agreement that doesn't say it is intended to be an employment contract, then that'll work too if the person to be charged signs that document. Well, nowhere in this agreement, my client, Mr. Condron, certainly didn't sign the collective bargaining agreement. No one said to him, oh, here's an agreement where you're agreeing to repay us for your training if you quit within a year. And so we're left with sort of the only applicable provision here. We've got no agreement saying my client cannot quit within the first 12 months of his employment. And Mesa Airlines says, well, we'll fix this. We'll just make him pay a penalty. And that's my argument, that one, it's contrary to the public policy, but just as importantly, associating a $12,000 payment for someone who quits a job that he has the right to quit under the laws of Arizona and saying, well, now you got to pay money, that's a bald penalty.
How is it a penalty when he's received consideration of the specialized training?
Well, the specialized training consideration was supposed to be paid for by the airline, of course, but he was obligated on the total amount of the note on the day he signed this promissory note. So before he received any training.
So under your construct, the airline can provide specialized pilot training to an individual who otherwise has not had it, can offer them, provide that training and a place to work, and as soon as they've completed that training, they can take the value of that training and go work for somebody else. Is that a reasonable business expectation for this industry?
Well, I think it is. I think it's common in this industry, unless there is an agreement that says the pilot will pay for the training, and collective.
Is that what the note is?
No, the note is a penalty because it's not payment. It's not related to the amount of the training.
But that was it seems to me, I may be wrong, but the value of that training was negotiated up front between the union and the airline.
Well, the value of the note is somewhere from the 1990s and simply has had a CPI ratcheting up over years, and it is totally disjointed from the value of the training. And in this case, the discovery that was had showed that you can decide to the penny what the cost of the training is.
Well, I think the airline actually argued that the cost of the training, the actual training, was substantially higher than the face amount of the note.
So then, if they can show that there is a breach, they ought to be able to show they get compensation for the breach of the agreement. And certainly they're entitled to put that evidence on if there's a breach of an agreement. But how can you breach an agreement that allows a person to quit at any time for any reason at his pleasure? So there's no breach, and I have to pay?
Well, we'll obviously let Mesa Airlines speak for itself, but my sense of their argument is they're not arguing this is a breach of an employment agreement. It's a breach of the promissory note.
Sure. And my argument is that these are contemporaneous agreements. They are inseparable. The law must look at the entire transaction on the day that my guy was employed. It just so happens that a part of the oral agreement was, here, sign this. And as my client was told by the guy who had him sign it, this is to make sure you don't quit in the first year.
The statute allows parties to an at-will employment agreement to amend or modify or add to that agreement with a written agreement. What in your view should have happened here to make this whole arrangement enforceable?
One of three things could have happened here. Number one, you could have had a written employment agreement that says, because we're providing you this training and it's going to cost $40,000 or whatever, if you quit in the first year, you agree to pay us back for that training. And if that was signed by both parties, that would work. And a sophisticated company like Mesa Airlines is in a position to anticipate and make someone sign that agreement. Number two, if they had a document like this collective bargaining agreement that says, or an employee handbook that says, this is your employment contract, this handbook, and you give it to the guy, then under the statute, that would bind my pilot. Or if you don't have a document that says this is anticipated to be a contract, then under the third part of the statute, you can say the employee handbook requires you to repay the training and you sign it, then you're also liable. So this is Mesa Airlines' predicament that they put themselves in because they didn't take advantage of one of the three ways to escape the fact that this promissory note is a part of the employment contract, not separable from it, and that what it is a penalty, has no relation to the damages, and there's no breach. So how do you recover when my client didn't really agree to pay? He simply signed a note which, as a policy matter, is unenforceable.
Yes, I'm having a hard time understanding the difference between the note and your first scenario.
Well, the note doesn't say anything about I'm going to repay for training. It doesn't say what this is for. The only thing is it says training promissory note at the top.
And for value received, I promise to pay $12,000.
Yeah. And what was the value to my client? Actually, it was zero.
Probably the training.
Well, but he never used that training when he left.
Well, but it was given to him.
Well, okay. Valueless. Would he have agreed to pay for the training to work for Mesa Airlines? Probably not. He wouldn't have left the other job. But we're getting off the realm of speculation, obviously. I just don't think that this note, as a part of the employment contract, can be separated from it. And it does not say in that note, I agree to pay for training. It says, you owe this money right now on September 3. You haven't begun your training. You own it in full. How can that be anything other than a penalty, a device designed to keep you working for 1 year under penalty of having to pay something, which for a captain at Mesa Airlines, this $12,000 note is bankrupted him. That's why he went into bankruptcy and why I'm special counsel for the bankruptcy estate.
Well, maybe I'm missing it, but I think you mentioned your client knew, as he was presented with this document, exactly what it was, that it was intended to compensate Mesa Airlines for the training it was going to provide and to keep him, theoretically, from bolting He knew that he would owe this money if he left, and he left. He chose to leave. I mean, I'm trying to understand the equities here, and I'm not seeing it.
Well, I'm not sure that we're talking about equities in a case like this. The issue is he was told, this is designed to keep you here for a year. That's why you're signing the note.
But it was his decision to leave.
Of course.
A matter of days after this training's completed.
Yeah, he'd been working there for maybe 4 or 5 months.
Well, the
when he
record
left.
we have is that he after his training was completed, he completed
Started in September.
12 hours.
Yeah, he started in September, 12 hours of flying. He started in September. He didn't leave until mid-December.
Right.
Okay, I'm saving the rest.
All right.
I appreciate your questions, by the way.
Thank you, counsel. Mr. Waugh.
Good morning, Craig Waugh for Mesa Airlines, Inc. I think that the trial court summarized the undisputed facts in the case well in the minute entry dated March 31st, 2016. That's record document 68. Judge Gerlach found it is undisputed that when Condron first began discussing employment with Mesa Airlines, he was not qualified for the pilot's position for which he later was hired. To become qualified, he required additional training and a type rating. Mesa Airlines offered Condron the opportunity to receive that training and obtain that type rating, which is an offer that Condron accepted. The training was provided and Condron received the type rating. Before anyone agreed to anything, Mesa Airlines made it known to Condron that the fee for the training, including the type rating training, was $12,712. Mesa Airlines also made it clear to Condron that he would be obligated to pay for that training. Instead of turning down the offered employment and the training that it required, Condron agreed, and instead of paying the fee immediately, Condron confirmed his promise to pay for the training by signing a promissory note. Now, this case is a promissory note case. The promissory note required Mr. Condron to pay the balance then owing after applying credits that were provided to him for the term of his longevity with the company upon demand. He received the demand. There's no dispute in this case that the demand was equal to the balance on the promissory note at the time the demand was served, and he refused to pay upon demand. And that's the breach, not his decision to leave his employment within a year, but his decision not to pay the amount due upon demand by Mesa Airlines.
Well, Mr. Williams argues that this note really is supposed to be a training agreement, and it's not a training agreement, and it's not signed by both parties, and so under his view of the world, it's not enforceable. So what's your response to that?
The collective bargaining agreement provides for training agreements between the airline and the pilots. The promissory note that is at appendix page, begins at appendix page 24 of appellee's answering brief, is a copy of the JET training event promissory note. This promissory note adheres to the specifications in the collective bargaining agreement, section 11H, for the training agreement. It provides the straight line amortization of the balance. It provides that if he gives 45 days, I believe, written notice of his intent to terminate, that the balance is reduced by half. It contains all of the stipulations in the collective bargaining agreement for the training agreements. And in this case, there was never a dispute that the promissory note was something other than the training agreements contemplated by the collective bargaining agreement. With respect to the public policy argument, that relies exclusively on the Employment Protection Act, ARS 23-1501A, and specifically A2. And the end of that paragraph, which was found in the Red Mountain Spa case to be not a model of clarity, which it certainly is not, the paragraph ends with the language that nothing in the foregoing sentences shall affect employees' and employers' rights under collective bargaining agreements. There's an exception to any of the arguments that could be constructed under the previous language for when there's a collective bargaining agreement. And here there is that provides for these agreements to be made between employer and employee. So on that basis alone, the collective bargaining agreement exempts this from a public policy issue. But the last antecedent arguments that were made in the reply brief also don't work. The first sentence of 1501A2 states that it is the presumption that employment is severable at the pleasure of either party, but then creates an exception, which is a written contract. And that first sentence of the paragraph defines what the written contract is. The second sentence stipulates what's required for that written contract to be enforceable. Either both parties sign it, presumably because it requires both parties, it has obligations for both parties, such as the employer can't terminate the employee before a specified time, and likewise the employee can't leave before a specified time. The second option, comma, or, is that the agreement is contained in an employee handbook, employee manual, or a similar document distributed to the employee and that states it's intended to be an employment contract. And the third, comma, or exception is when that written contract is signed by the party to be charged. And in this case, this is a promissory note that if it even does affect his ability to quit his position, is at a minimum a contract signed by the party to be charged with payment, Mr. Condron. So on both bases, the collective bargaining agreement exempts this agreement from the statute, as well as the fact that it's signed by the party to be charged. Mr. Williams argues that this agreement would be enforceable if Mesa Airlines had signed it as well. But what would that add, and what public policy does that support, that Mesa Airlines co-sign a promissory note to pay Mesa Airlines? The statute serves an evidentiary purpose. Similar to the statute of frauds, it requires that certain agreements be signed by the party to be charged in order to be enforceable. Requiring Mesa Airlines to sign a promissory note to itself in this situation would be meaningless, and is certainly not what the legislature intended by the statute. The penalty argument, likewise, fails because the promissory note is not an agreement to pay damages associated with quitting his job. As Your Honor noted in your question earlier, there's consideration for the promissory note. There is specific consideration for the promissory note, which is the training and type rating that he received. And so his agreement and requirement to pay for that does not constitute a penalty. It just constitutes the consequence of his bargain. These are my primary arguments. If you have any questions, I'm happy to answer those.
Questions? I think not, counsel. Thank you.
Thank you.
Well, one, the jet training event promissory note does not say what it's for. It doesn't say it's to pay for training. There is nothing before the record that says my client agreed to pay for training. The collective bargaining agreement says on page 32, this is appendix 28 to his brief, such required training shall be provided by the company. The company has to pay it. Later on, there is this training agreement provision, and we don't have one, which is permissive, which is in there at the behest of Mesa Airlines when we were deposing some senior vice president, Mr. Fervett, I don't recall his position. He admitted that that's in there because Mesa Airlines wanted it as a hedge against their promissory note. So we have a note that doesn't say it's for training, that's due and payable on full on the day that it's signed before there is any training. It's executed in conjunction with his employment. It's designed to keep him there for a year rather than allow him the pleasure of quitting any time. So it violates the policy of the state. They could have done this correctly, but they did not. The burden is not on my client, a pilot, to understand all the legal niceties of how to do that. And with respect to Mr. Wall, it has never been my position that anything would have been gained by Mesa Airlines signing the promissory note. No, that was not my position. My position is if you take the last antecedents, as outlined on page 4 of my reply brief, The only one that could possibly work in this case, according to Mr. Wall, is the last one, and that's where if you have a collective bargaining type agreement or a handbook, if it doesn't say it's a contract of employment, it's still enforceable to the terms that it provides if the employee signed it, which did not happen in this case. So it's a penalty. It's contrary to the policy. There was no breach. They don't get damages. If the contemplation of the parties is that because I'm giving you training, you're going to continue to work for me, otherwise I'm being damaged, then you have to make him bound to be employed for a term rather than penalizing him if he quits. Basic contract law, they didn't do it. I'm done.
Doesn't the A2 exception in the statute apply here?
You know, the A2 exception, the A2 exception does not apply. That's what I cite. Because the first part of A2 is an agreement signed by both parties. The second part is, or this written contract, which is described in the foregoing, this employment agreement, must be set forth in an employment handbook or manual or any similar document, if that document expresses the intent that it's an employment agreement. So that part doesn't work. So you go to the next clause, or this written agreement, that is the employment handbook, manual, similar document, the collective bargaining agreement would fit within this, must be set forth in a writing signed by the party to be charged, and it wasn't.
The note.
No, the note is not an employment agreement of any sort. It's a part of it. It's not an employment. It doesn't say you got to work for a year. All it says is, on the day you start, you're owed. You got to owe me $12,000 if you quit tomorrow. And I think the case that we cite in our brief, the Nosfinger case, is pretty apropos to this situation. Anything else?
No, thank you, counsel.
Thank you.
Appreciate the arguments here this morning and the briefing on this matter. I will take this case under advisement and issue our written decision in due course. We're going to take a short recess to allow the parties in the next argument to come forward and get set up for that. And so, thank you.